Exploring bizarre medieval laws. Medieval Europe was a world governed not only by kings and clergy, but also by a bewildering tapestry of legal customs. Beneath the heavy shadow of monarchy and ecclesiastical power stretched a framework of laws as peculiar as they were punitive. These regulations were designed to enforce order in a chaotic age, but many of them defy modern logic. From forbidding certain clothing to conducting full criminal trials for animals, medieval law reveals the strange logic of a society shaped by status, superstition, and sacred authority. Let's explore 5 of the most bizarre and captivating legal practices of the time: sumptuary laws, trial by ordeal, animal trials, curfew laws, and forest laws. Through narrative storytelling, case studies, and contextual analysis, we illuminate the harsh realities, dramatic moments, and ideological underpinnings of these forgotten customs, reaching toward a fuller understanding of medieval law and its enduring legacy. Sumptuary laws, the tale of a tailor's rebellion. In the stratified society of medieval Europe, clothing was more than a matter of taste or fashion, it was a visual manifestation of social hierarchy. What one wore could instantly communicate wealth, marital status, profession, and, most critically, class. As early as the 13th century, kingdoms across Europe, particularly England, France, and various Italian city-states, enacted sumptuary laws to control who could wear what, based on social rank. These regulations were not suggestions but enforceable mandates, frequently tied to specific penalties such as fines, public shaming, or even imprisonment. The stated intention of sumptuary laws was twofold: to maintain moral and social order, and to curb excessive spending on luxury goods that could destabilize both households and economies. Yet the underlying motive was more insidious: the preservation of class distinctions. The nobility feared that the rising merchant class and newly wealthy commoners might blur the visual lines that kept aristocratic privilege intact. If a wealthy butcher's wife could wear silk or ermine, what separated her visually from a baroness? It was this anxiety that lay at the root of repeated legislative attempts to legislate appearance. In England, the Statute of 1363 under Edward III was among the most elaborate expressions of this trend. It carefully delineated what materials, colors, and accessories were permitted at each level of the social pyramid. Artisans and yeomen were forbidden from wearing cloth of gold, imported furs, or embroidered garments. Women of low rank could not wear veils of silk, and shoes with exaggerated points, known as poulaines, were similarly regulated. These laws were policed by local officials and guild masters, whose job it was to report violators and ensure conformity. Against this backdrop, the story of Geoffrey of Southwark unfolds as both protest and provocation. Geoffrey, a talented and entrepreneurial tailor operating in London's Southwark district, developed a loyal clientele among the city's increasingly affluent merchant class. His garments, admired for their elegance and craftsmanship, began to attract attention and trouble. Geoffrey began to craft doublets, gowns, and hoods using luxurious fabrics typically reserved for nobles. These were not mere imitations, they were statements of aspiration. His clients were wealthy, though not noble, and sought clothing that reflected their economic success. Soon, Geoffrey was summoned before the Guildhall and accused of violating the sumptuary laws. Court records from 1371 indicate that he was fined and prohibited from further tailoring for those beneath the dignity of knight. But Geoffrey's case had stirred something deeper. Pamphlets appeared in London defending the right of craftsmen and merchants to dress as their purse may afford. Rumours swirled that Geoffrey had received secret support from members of the merchant guilds, many of whom chafed under the constraints of an inherited order that denied them status despite their wealth. This episode was not isolated. Across Europe, similar tensions were playing out. In Florence, a hub of textile innovation, tailors often ignored sumptuary laws with impunity during festival seasons. In France, Queen Isabeau was famously criticized for dressing her attendants in lavish attire that blurred class lines. While lawmakers passed new statutes with each generation, enforcement was spotty and often selective. The laws persisted on paper but increasingly lost their cultural power. Historians such as Susan Crane and Ulinka Rublak have argued that sumptuary legislation functioned as a kind of moral theater, less about actual enforcement and more about reinforcing elite ideals in a world undergoing economic and social transformation. In that sense, Geoffrey's rebellion was not merely sartorial, it was ideological. He challenged the assumption that identity must be static, that birth should dictate worth, and that law should codify appearance as a tool of exclusion. In modern terms, sumptuary laws seem archaic or even absurd. Yet they invite reflection on contemporary dress codes, social signaling, and how wealth continues to shape perceptions of legitimacy. Geoffrey's story, while steeped in the fabric of medieval law, remains a timeless meditation on the desire for visibility, dignity, and social mobility. Trial by ordeal, the legend of the innocent blacksmith. One of the most dramatic and harrowing manifestations of medieval justice was the practice known as trial by ordeal. Rooted in early Germanic law and later codified under Christian influence, ordeal trials were based on the belief that God would intervene on behalf of the innocent. In a world where legal proof was scarce, where few could read and judicial structures were still forming, divine judgment offered a final recourse that transcended human fallibility. There were several types of ordeals, each prescribed for different offenses. The ordeal of fire involved holding or walking upon burning objects. The ordeal of water, either hot or cold, required the accused to retrieve an item from boiling liquid or to sink, innocence, or float, guilt, in blessed cold water. In some regions, ordeals included ingestion of the Eucharist under duress or exposure to poison. These rituals were usually conducted under ecclesiastical supervision, with prayers and blessings sanctifying the judgment. A case that has lingered in English memory is that of Wulfgar, a humble blacksmith in the village of Lydd in Kent. In 1192, Wulfgar was accused of stealing a golden crucifix from the priory of St. Mildrith. He had been seen in an argument with one of the monks shortly before the theft was discovered, and rumor quickly supplanted fact. Despite his years of loyal service and a reputation for fairness, Wulfgar found himself before the abbot's tribunal. Wulfgar maintained his innocence. As there were no witnesses and the relic had not been recovered, the court demanded an ordeal of fire. In front of the gathered villagers, clergy, and reeve, Wulfgar was made to walk 9 paces across red-hot plowshares. He did so without a cry. His feet were then wrapped in linen and sealed by the priest. If after 3 days his wound showed signs of festering, guilt would be assumed. If the burns were healing cleanly, he would be judged innocent by divine will. 3 days passed in anxious silence. On the 3rd morning, the priest, the abbot, and several townsfolk gathered to unwrap the linen. To the astonishment of all, Wulfgar's burns had begun to scab and heal. The verdict was read aloud, innocent. The monk who had accused him fell into disfavor, and whispers emerged that the real thief had fled the region entirely. Wulfgar's life changed irrevocably. Though he returned to his forge, he became a somber figure in local law, revered and pitied. Pilgrims visited to see the blessed blacksmith. His tale was immortalized in a stained glass window decades later. Yet despite the miracle, the injustice of the ordeal left its mark, not only on Wulfgar's feet, but on the community's conscience. Trial by ordeal was not without its critics even in the Middle Ages. As early as the 9th century, bishops such as Agobard of Lyon expressed skepticism. By the 12th century, canon lawyers like Gratian began compiling arguments against ordeals in the Decretum. Ultimately, the Fourth Lateran Council of 1215 formally banned clergy from participating in ordeals, effectively ending their legitimacy. Secular authorities slowly transitioned to jury-based trials, particularly in England under Henry II's legal reforms. Nevertheless, ordeal trials persisted in isolated rural areas for decades thereafter, especially where local custom outweighed centralized reform. In parts of Scandinavia, trial by ordeal was practiced well into the 14th century. And in places where written contracts, forensic evidence, or impartial courts were absent, the spectacle of divine justice retained a hold on the imagination. Modern scholars, including Peter Brown and Robert Bartlett, have interpreted ordeal as a ritual of communal purification. It was not merely about guilt or innocence, it was about restoring cosmic and social balance. In communities knit by shared fears and faith, ordeal affirmed collective morality. The accused became a vessel through which the community reaffirmed its values under divine oversight. Wulfgar's ordeal exemplifies both the cruelty and the sanctity perceived in medieval justice. To modern eyes, walking on fire seems a barbaric test. Yet in its own cultural logic, it was a test of truth that bypassed earthly corruption. It reminds us that justice is always shaped by the beliefs of its time, and that the border between righteousness and ritual is often blurred. Animal trials, the curious case of the pig on trial. In perhaps one of the most astonishing aspects of medieval legal culture, non-human creatures were, at times, treated as full subjects of the law. From pigs to cows, from goats to swarms of insects, animals were placed on trial, formally charged with crimes ranging from murder to vandalism. This phenomenon, known today as animal trials, may strike modern readers as absurd, but in the medieval mindset, it was an entirely logical extension of a moral and cosmological worldview. The foundational assumption behind such trials was that all of God's creations were subject to divine and, by extension, earthly law. If a pig killed a child, or if a flock of locusts devoured a harvest, they had violated a sacred order and thus had to be held accountable. These proceedings were conducted with genuine legal decorum. Animals were assigned legal representation, charges were read aloud in court, and punishments were formally pronounced. A celebrated example occurred in 1386 in the town of Falaise in Normandy. A pig was accused of attacking and killing an infant left unattended in its cradle. The act of infanticide horrified the villagers, and the authorities acted quickly. The pig was arrested, placed in custody, and a trial date was set. It was provided with a legal advocate, Jean Lavoisier, who attempted to argue that the sow had been provoked or inadequately restrained, placing blame on the animal's owners. The court, however, was unswayed. Multiple witnesses testified to the pig's ferocity and unnatural behavior. The trial lasted 3 days, with the animal paraded in chains, and ultimately ended in a guilty verdict. The pig was dressed in a human tunic and executed by hanging in the town square before a crowd of solemn onlookers. While this case may seem grotesque or theatrical, it reflected broader medieval conceptions of justice, guilt, and agency. To try an animal was not merely punitive, it was restorative. Such trials reaffirmed communal values and assuaged fears of disorder. By symbolically reintegrating the crime into a comprehensible moral framework, the community could move on. Ecclesiastical courts also held proceedings against animals and even insects. In 1519, the commune of Stelvio in northern Italy brought legal charges against a group of field mice accused of destroying crops. The court appointed them a Franciscan friar as counsel. The friar argued that the mice had been driven by hunger and natural instinct. In a compromise ruling, the judge declared that the mice would be excommunicated but given 8 days to vacate the region peacefully. Legal scholars and theologians debated such matters with surprising seriousness. Some argued that animals lacked moral agency and therefore could not be punished. Others countered that God's justice applied to all creatures. The philosopher Albertus Magnus, for instance, suggested that animals had a natural role in the moral order and could, under specific conditions, be judged. In some cases, the animals won. A famous trial in 1457 saw a group of rats accused of consuming a parish barley reserves. Their lawyer, Bartholomew Chassani, argued that the rats could not appear in court due to the dangers of travel, including the risk of being eaten by cats. The court accepted the argument and adjourned the case indefinitely. Chassani later became a prominent jurist, his career launched by his unlikely defense of rodents. Animal trials were gradually phased out as legal rationalism and scientific understanding grew. By the 17th century, they had become rare, confined mostly to isolated rural communities. Yet their legacy remains. They remind us that law is as much a cultural performance as it is a codified system. In trying animals, medieval people enacted rituals of control, order, and meaning in a world that often seemed chaotic and cruel. Today, scholars interpret these trials not as literal attempts to ascribe guilt, but as allegorical or ritualistic processes. They reflect the medieval desire to find justice not only among humans but in the natural world itself. In their strangeness, they offer a mirror through which we see the boundaries of our own legal and moral assumptions. Curfew laws, the night watchman's dilemma. In medieval towns and cities, where houses stood shoulder to shoulder and streets were narrow and flammable, the risk of fire was ever present. Curfew laws arose as a practical solution to a very real danger. These laws required residents to extinguish their hearth fires and refrain from lighting lamps past a designated hour. The term curfew itself comes from the Old French couvre-feu, literally meaning cover fire. It was a nightly ritual that combined safety regulation with social discipline. As towns expanded during the 12th and 13th centuries, particularly in England, France, and the Low Countries, municipalities took on more responsibility for urban order. The nightly ringing of the curfew bell marked not only the hour when fires should be covered but when activity should cease. Market stalls closed, alehouses shuttered, and the streets gradually emptied. The rationale was both preventive and punitive. Any fire lit after curfew was deemed reckless and potentially criminal. In the northern English city of York, the role of enforcing curfew fell to the town's network of night watchmen. These men were appointed by local aldermen and were often veterans, apprentices nearing guild membership, or men of modest means seeking civic favour. One such watchman, Edric of Bootham, became something of a local legend. Edric was known for his unwavering commitment to curfew enforcement during the late 1200s. Each evening, he lit his iron lantern and made his rounds through the timber-lined lanes of the Shambles and Merchant Quarter. He carried a horn to signal infractions and a baton to ensure compliance. While many watchmen turned a blind eye to minor breaches, Edric was famously unyielding. He once fined the wife of a tanner for leaving a brazier smouldering and refused to waive a penalty for a visiting noble servant who carried a torch after hours. One night, Edric encountered a group of young apprentices drinking and singing outside a tavern after curfew. Among them was the son of a powerful guild master. Edric warned them, but they mocked his authority. Rather than retreat, Edric summoned the town constable, and all were arrested and fined. The next morning, the guild master confronted the mayor, demanding Edric's dismissal. But the mayor, invoking the recent memory of a devastating warehouse fire that had leveled half a street, sided with the watchman. Edric's steadfastness became a model of civic virtue. Curfew laws were more than fire prevention, they were a form of urban discipline. They reflected broader concerns about nocturnal crime, drunkenness, and public disorder. The night was considered a time of moral and physical vulnerability. In Christian theology, darkness symbolized temptation and sin. In practice, it was a time when theft, assault, and arson were most likely to occur. The curfew bell thus served as both a civic alarm and a moral boundary. These laws vary by region. In Paris, the curfew was often set at sunset, whereas in London it might be adjusted seasonally. Some towns allowed exemptions for certain classes, physicians, midwives, or priests, but only if they carried special permits. In Venice, curfew enforcement was paired with lantern ordinances requiring late-night travelers to carry visible lights under penalty of fine. By the late medieval period, curfew laws began to evolve. With the rise of guild-sponsored patrols, more sophisticated fire brigades, and growing state centralization, the enforcement of curfews shifted from local custom to state directive. Yet in many communities, the ringing of the evening bell remained a cherished tradition. Historians see curfew as emblematic of the medieval city's attempt to control its environment. Where daylight brought commerce and order, night threatened regression and chaos. Curfew laws thus bridged the practical and the symbolic, a tangible regulation of danger, and a ritualistic marking of civilization's edge. Today, echoes of the medieval curfew can still be found in emergency legislation, youth ordinances, and fire safety codes. Edric's story, whether myth or memory, reflects a deeper truth that societies have long depended on routine, vigilance, and the quiet courage of ordinary people to keep danger at bay. Forest laws, the outlaw's revenge. Among the most resented and socially divisive legal codes of the Middle Ages were the forest laws, royal statutes that placed vast expanses of land under the exclusive dominion of the king. These laws not only regulated the natural environment but restricted the rights of ordinary people to hunt, forage, fish, and gather firewood in designated royal forests. The word forester in this context did not imply dense woodlands, but any land, field, pasture, heath, or wooded area that had been afforested under royal decree. Instituted under William the Conqueror and expanded during the reigns of Henry I and Henry II, forest laws aimed to preserve game for royal sport and maintain control over lucrative timber and grazing lands. The penalties for violating these laws could be harsh. Poaching a deer or even disturbing the soil could lead to fines, imprisonment, mutilation, such as blinding or loss of fingers, or death. To many, these laws symbolized an oppressive imposition of elite privilege upon peasant survival. One tale from Sherwood Forest, immortalized in legend, but rooted in plausible reality, is that of Ealric, an outlaw born of grievance and necessity. Ealric's father had once been a royal forester but was dismissed and punished for taking a deer to feed his starving family during a harsh winter. The act cost him his post and, ultimately, his life. Ealric grew up amid bitterness, watching the king's hunts proceed while villagers foraged in desperation. By his early 20s, Ealric had become the leader of a band of dispossessed peasants, charcoal burners, and escaped villains. Together, they raided hunting lodges, liberated traps, and redistributed poached game among sympathetic locals. Their actions were not simple banditry, they were acts of rebellion. Ealric's most daring exploit involved sabotaging a royal hunt by luring wild boars into the king's path and causing a stampede. In the chaos, one nobleman was injured, and the king's prized greyhound was killed. Ealric's defiance was met with swift retribution. A royal warrant was issued, and a reward offered for his capture. After months of evasion, he was betrayed by a former ally, seized by foresters, and dragged in chains to Nottingham. The trial was swift, the verdict predetermined. Ealric was hanged at dawn before a jeering crowd. Yet even as he died, his story began to spread, first in hushed ballads, then in tales passed from village to village. Some believe his legend helped shape the myth of Robin Hood. Forest laws did not go uncontested. Throughout the medieval period, villagers submitted petitions to Parliament, protesting unjust fines or the expansion of afforested lands. In 1217, the Charter of the Forest was issued as a companion to Magna Carta. It rolled back some of the most severe forest restrictions, restored common rights, and promised fairer trials in forest courts. Yet enforcement remained uneven, and conflict continued. These laws were more than environmental policy, they were about power. By monopolizing access to land and game, the monarchy reinforced feudal hierarchies and restricted mobility. The forest became a metaphor for the state, expansive, hidden, and fiercely protected. Historians today interpret the forest law system as an early expression of state environmental control, but also as a mechanism of social stratification. Figures like Ulrich represent a recurring theme in history, the outlaw hero who breaks unjust laws to restore natural justice. His tale resonates with modern themes of ecological stewardship, resistance to inequality, and the enduring human bond to land. Justice, power, and the strange logic of the Middle Ages. The medieval world of law was one in which justice, power, piety, and spectacle intermingled in fascinating and often disturbing ways. The bizarre legal practices explored in this essay, sumptuary laws, trials by ordeal, animal trials, curfew regulations, and forest laws, were not isolated curiosities, but deeply embedded mechanisms that reflected the fears, values, and hierarchies of their time. Each law reveals a society that sought order in a world plagued by unpredictability, where plague, war, famine, and shifting social structures made stability a precious commodity. In regulating clothing, the state attempted to free status and prevent social mobility. In ordeals, it sought divine arbitration where human systems faltered. In animal trials, it extended morality into the natural world, while curfews embodied the fear of the unknown that night represented. And in the forest, the crown claimed dominion over land and life, stifling common rights in the name of royal prerogative. To modern eyes, these laws may seem irrational or even barbaric. But to those who lived under them, they offered a framework of predictability and, however flawed, a sense of justice. Law was not merely a bureaucratic instrument, it was a cultural performance, a spiritual rite, and a social negotiation. These legal customs also reveal the mechanisms by which authority was asserted and contested. The tailor who challenged sumptuary law, the blacksmith who submitted to fire, the pig that faced trial, the watchman who upheld the bell, and the outlaw who defied the forest, all became part of a broader narrative about the limits of law and the resilience of human dignity. They remind us that legal systems are never neutral, they reflect the priorities of those who create and enforce them. In examining these stories, we gain more than historical insight, we hold up a mirror to our own assumptions. Questions of social mobility, access to justice, state control over nature, and the role of ritual in public life are still very much with us. The strangeness of medieval law challenges us to reconsider what we take for granted in our own systems. Ultimately, the study of bizarre medieval laws is not merely a journey into the past, but a confrontation with the perennial human struggle to define justice, wield power, and navigate the boundaries of order and chaos. Through the lens of the peculiar, we gain a clearer vision of the enduring complexities that shape legal and moral life across the centuries. Thanks for watching. Like, comment, and please subscribe as that will help us get more videos out to those interested in the Middle Ages. See you next time on Medieval Chronicles 1066. Stay curious.